Welcome to today's discussion, Interstate Succession, Who Inherits if There Is No Will? This presentation is proudly brought to you by Schoeman Law Incorporated. We are a boutique law firm based in Cape Town, South Africa. We specialize in serving the needs of the entrepreneur. For more information about us, feel free to visit our website on www.schoemanlaw.co.za. I am Sixolile Timothy, and I am excited for the opportunity to present to you today. I am an attorney of the High Court of South Africa and a professional assistant at Schoeman Law Incorporated. I specialize in commercial law, contract drafting, property law, the administration of deceased estates, and dispute resolution. Please note that this presentation and its slides are copyright protected. Accordingly, this presentation and its slides are only being shared today for educational purposes and do not constitute legal advice. Should you require legal advice or would like to know how today's presentation could affect you, please feel free to contact us for a consultation. You can find our contact details on our website. Before we get into who inherits, it is important to first understand what we mean when we speak of interstate succession. When a person dies without a valid will, then we say they have died intestate. This means that the law dictates how their estate will devolve. This is dealt with by the Interstate Succession Act of 1987. This act provides for who inherits and how when the deceased has died intestate. In this instance, the deceased has no say on who inherits what, and they lose out on the opportunity to appoint an executor who administers the estate and a guardian for his or her children. The process of interstate succession can be quite lengthy, and I will now summarize the most important rules of interstate succession as contained in the Act. If the deceased leaves behind descendants and a spouse, as is usually the case, then the spouse of the deceased will inherit either an amount of 250,000 rands or a child's share, whichever is greater. The children will then inherit the balance of the estate per stirpes and with representation allowed. Per stirpes means that when a beneficiary dies before the person whose estate is being divided, his or her descendants will inherit his or her share as a group. So, if one of the deceased's children die, then that child's descendants will inherit in their place. A child's share is determined by dividing the estate through the number of surviving children of the deceased children who have left issue, plus the number of spouses who have survived such deceased. If the value of the estate is less than 250,000 rands, the surviving spouse will inherit the whole estate, and the children or descendants will not inherit anything at all. If a deceased does not have any descendants, then their spouse becomes the sole heir of their estate. In the case of more than one spouse, the spouses will inherit the estate in equal shares. The Constitutional Court has held that partners in a permanent same-sex life partnership should also be regarded as spouses for the purposes of interstate succession. It is important to note that when there is no will, the matrimonial property regime will still have an effect on the distribution of the estate. The surviving spouse of a marriage and community of property will first receive his or her undivided half share of the joint estate before the deceased estate is divided. The other half of the deceased estate will then devolve according to the rules of interstate succession. If the deceased spouse passed away before the deceased, then the descendants will inherit the estate in equal share per stirpes and with representation. Adopted children are also entitled to inherit. The Act also states that illegitimacy does not affect the capacity of a blood relation to inherit interstate from another blood relation. This means that children born out of wedlock are also entitled to inherit. If the deceased has no spouse, no descendants, but leaves behind both parents who are still alive, the parents will inherit in equal shares. If only one parent is alive, but the already deceased parent still has descendants who are alive, the surviving parent inherits one half of the estate, and the descendants of the deceased parent inherit the other half per stirpes. Otherwise, the surviving parent is the sole heir of the estate. In the case where the deceased does not leave a spouse or descendants, or no parents are alive, the descendants of their parents will inherit the half shares that would have been inherited by their respective parents, per Sturby's with representation. If only one of the predeceased parents have descendants, they are the sole heirs of the estate. If the deceased does not leave behind a spouse or descendants or parents or descendants of parents, the deceased's nearest blood relation will be the sole heir of the estate. If all these rules are exhausted and the deceased left behind no one eligible to inherit his or her estate, the estate devolves on the state. The executor converts the intestate estate into cash and pays the deceased's debts. The residue is paid into the guardian's fund. If no one can prove that they have a claim to the estate as an intestate heir, the money will accrue to the state after 30 years have elapsed. Executing a legally valid will that complies with the requirements and formalities set by law has practical advantages for the deceased and his or her heirs. It helps regulate and stipulates who inherits what from the estate and determines how the deceased's debts are to be settled. The deceased can state whether they prefer burial or cremation and can specify details relating to the funeral. It also enables the deceased to nominate a guardian for his or her minor children to ensure that they are physically and emotionally taken care of. They can also create a testamentary trust to benefit certain persons or for the benefit of the minor children. A will allows the deceased to nominate an executor and make provision for the payment of security to the Master of the High Court. Finally, it allows the deceased to formulate and integrate estate planning strategies into the deceased estate, resulting in the said estate only paying necessary taxes, and also that the administration of the deceased estate runs as smoothly as possible. Without these provisions, the administration process is delayed for long periods of time, which often results in financial hardships for those left behind. It is further also a big cause of family disputes, which can sometimes cause permanent damage to these relationships, all of which can easily be avoided by just executing a legally valid will. Having a legally valid will is the only way to ensure that the deceased's wishes are carried out. Having a will professionally drafted further ensures that the administration of the deceased estate is done effectively and concluded as soon as possible. Thank you for joining us for this presentation today. We would love to connect with you. If you have any questions regarding this discussion, or if you need any further advice, we offer several options for consultations. Please feel free to contact us on any of the details listed on the slide. Also, should you have any suggestions regarding future topics, feel free to email us at inquiries@schoolmanlaw.co.za. We look forward to connecting with you again soon.